Rank 1, the law clerk. You entered the law believing it was a system for finding truth. Then you watched it produce outcomes that were perfectly legal and morally unbearable. At 24, you are $204,000 in debt, earning $61,000 a year, spending your first year writing answers for a judge to deliver under her name. You do not argue. You do not decide. A bench memo is a document you produce so the judge can walk into a hearing already oriented. You write these. You research what she has no time to research. You draft portions of opinions published under her name. You decide nothing. Judge Voss reads your first memo, marks it in red, returns it without looking up. The marks are not wrong. That is the part that stays, not the corrections, but the accuracy of them. You assumed proximity to the work would feel like proximity to justice. It feels like proximity to a machine that runs whether or not you understand it. Mercer, a senior judge 2 suites down, nods at you in the corridor on a Tuesday. Nothing more. You will not understand why you remembered that until much later. You are 24. You think the hard part was getting here. Rank 2, the assistant United States attorney. You are 26, and for the first time your words in a courtroom carry consequence. An officer represents the federal government in criminal cases. You charge, you argue, you examine witnesses, you make decisions that determine whether someone is prosecuted or not. You are not a judge. You are not close to being one, but you are no longer summarizing other people's work. The office assigns you to general crimes first. Small frauds. Minor federal offenses. Cases with no political complexity and no one watching. You try 4 cases in your first year. You win 3. The 4th turns on a suppression issue you didn't see coming. The defense attorney files a motion arguing the search was unconstitutional. You research it overnight. She is right. You notify your supervisor. The case is declined. You go back to your desk. You win cases and decline cases, and you begin to understand that winning is not always the right outcome, and that this gap is not a problem to be solved. It is a condition to be managed for the rest of your career. End of year 2. Loans at $181,000. You have won cases, declined cases, and learn that the law can ask you to do something cleanly without ever making it feel clean. Rank 3, the state court judge. Appointed by the governor at 31 after 18 months of committee review and a confirmation vote you watched from a hotel room at 11 p.m. Your name is on the door. The nameplate is standard issue. You notice this and say nothing. A state circuit court judge has general jurisdiction, civil disputes, felony trials, family matters, probate. You handle everything. In your first month, a drunk driving trial, a custody dispute involving allegations of abuse, a civil suit over a $2.3 million construction contract. None of these are simple. All of them are someone's entire life at that moment. The moral wound arrives in month 4. The defendant is Dale Rourke, 41 years old, charged with aggravated criminal sexual assault. The victim is 22. The evidence is detailed and not ambiguous, but the primary physical evidence was collected during a search the officer extended without documented justification. The exclusionary rule is clear. Evidence obtained through an unconstitutional search cannot be used, regardless of what it proves. You hold a hearing. You rule. The evidence is suppressed. Without it, the prosecution cannot proceed. The charges are dismissed. Rourke walks out of the courthouse on a Tuesday morning. The victim's mother is in the hallway. You see her from the corridor as you walk back to chambers. You do not stop. The law was followed correctly. Rourke walked. Both things are true. The law has no procedure for what you feel standing there after that. You don't sleep well for 2 weeks. There is nothing procedurally to revisit. You made the correct ruling. That is the part that stays, not that you failed, but that you didn't. End of year 1 on the bench. 31 years old. Loans at $163,000. One case that will follow you for the rest of your career and no record of having done anything wrong. Rank 4, the federal magistrate judge. 34 years old. 8-year renewable term. The district judges above you can reverse anything you decide. De novo, meaning as if you never ruled at all. Your jurisdiction is limited to pretrial matters, detention hearings, misdemeanor cases. You handle the volume the district court doesn't have time for, which is most of the volume. 6 weeks in, a civil contract dispute lands on your docket. Routine. The firm's primary investor traces through a holding company to Senator Aldrich Maine, 3-term incumbent, Senate Judiciary Committee, the committee that oversees federal judicial appointments. You note it in the file. You rule correctly. Nothing happens. Maine's name goes into the record. You will think about it again. Your first detention hearing as the sole decision maker involves a man charged with second-degree murder. The evidence is substantial. You order detention. He disappears through the side door. You go back to chambers and review the next file because tomorrow's docket still has 11 matters on it. By end of year 1, 340 matters ruled on, 6 reversals. Each one arrives as a one-sentence order. No explanation. You read each one looking for the lesson and find only the conclusion. Your partner asks when the hours will change. You say when the district court appointment comes through. That is not what was being asked. You both know it. 35 years old. Loans at $144,000. Maine's name in a file you have stopped thinking about. Rank 5, the federal district judge. 38 years old. Presidential nomination. FBI background check. Senate judiciary hearing. 11 months, a party line vote, and the title is yours for life. Article the 3rd. Removable only by impeachment. When you enter the courtroom, the deputy says all rise and means it. Full jurisdiction now. Jury trials, sentencing, injunctions. A pharmaceutical company concealing clinical trial data. A civil rights suit against a police department. A death penalty appeal. These are not contract disputes. These are the cases that determine whether someone goes home or spends the rest of their life in a federal prison. Then Maine moves. 18 months in, you rule against a development company with documented ties to Maine's PAC. 3 weeks later, a formal judicial conduct complaint arrives at the 7th Circuit Judicial Council. Alleged bias against business interests, procedural irregularities, temperament concerns from unnamed court staff. 4 pages, every word chosen to sound credible without being specific enough to disprove quickly. 30 days to respond. You don't sleep for a week. Mercer acts without asking your permission. She files a written submission to the special committee. Your reversal rate, your case logs, evaluations from every judge who has observed your courtroom. 3 weeks later, the complaint is dismissed. File clean. She didn't tell you what she agreed to. She said it was handled. You chose to believe that was the whole answer. It wasn't. You knew that while you were believing it. Your partner leaves. Papers signed during a recess on a Thursday. You go back upstairs because the docket does not stop for the collapse of a marriage. 38 years old. Loans at $121,000. File clean. Mercer tired in a way she wasn't before. Rank 6, the federal district judge in her 7th year. The title hasn't changed. What's changed is that Maine can't reach you directly anymore. 7 years of published opinions, a reversal rate below the circuit average, a record clean enough that a second complaint would invite scrutiny he can't afford. So he reaches Mercer instead. You find out indirectly too late to change it. Mercer files a recusal notice in an environmental matter tied to Maine's donor network. The stated reason is procedural, a prior advisory opinion touching a peripheral legal question. Nothing in the notice is false. It lands 3 weeks after Maine's people would have had full visibility into the assigned docket. You note the timing. There is no formal mechanism for raising it. You ask Mercer if she is all right. She says yes. She looks tired in a way that has stopped being temporary. You don't push. The near miss happens on a Tuesday, week 6 of a civil rights trial. You are reviewing a draft injunction in a civil rights case when your clerk says your name once, quietly. You look down and realize you used the wrong standard. Your draft applies the wrong evidentiary burden to the third factor. Your clerk says your name once, quietly. You stop. You reread the paragraph. You rewrite it. The order issues correctly at 4 p.m. That night, you replay the original paragraph for 3 hours. A mandatory wellness referral follows. A therapist, burnout, compassion fatigue, early PTSD markers. Past events returning as present experience. More than 60% of federal judges report chronic stress at clinical levels. Nobody discusses this at conferences. You cover for Mercer at a judicial conference in October. An excuse she gave you. You deliver it without hesitation. You have now covered for her twice in 6 weeks. You have known what it means for longer than you have been willing to say. Rank 7, the federal circuit judge. Confirmed 61 to 38. The letter arrives at your desk. You read it, set it down, go back to the brief in the corner because it is due for conference in the morning. 4 months later, a court administrator pulls you aside. A court reporter who has worked the building 19 years saw something in Mercer's courtroom the previous Tuesday. Mercer's hands, during a bench ruling. The court reporter doesn't know who else to tell. You already know. The Judicial Conduct and Disability Act provides the mechanism. File through the Circuit Judicial Council. Confidentially. triggering a mandatory independent evaluation. If impairment is confirmed, judicial duties are suspended. You file through the correct channel. You do not tell Mercer first. Telling her first would allow her to manage the appearance of the problem rather than the problem itself. The distinction is the only one that matters. 3 weeks. Progressive neurological condition, early stage, directly relevant to judicial function. Mercer is placed on administrative leave. Her docket redistributed. Her chambers go quiet. She calls once, 10 days later. She knows. She doesn't say so. She asks about a case you closed 2 months ago. You talk for 6 minutes. She says she's tired. You say you know. That is the last real conversation you have. You did the right thing. The DOJ public integrity referral on Maine goes out the same week. The timeline, the complaint, Mercer's recusal, the financial connections. Factual. Complete. It will take years. It may go nowhere. You send it because the alternative is knowing you didn't. Voss retires that spring. 41 years. A named courtroom. Everyone stands and applauds. You stand. You applaud. He built something real. That is also true. 39. Loans gone. Mercer's number still in your phone. Rank 8, the Chief Circuit Judge. 10 years on the circuit. You are now the administrative head, responsible for every judge in the circuit, the docket, the budget, the clerkship program. You still write opinions. That is the one part of the job that remains what you trained for. The Hargrove chemical file arrives in 2 bankers' boxes on a Tuesday morning. Class action. 847 plaintiffs. Hargrove knowingly discharged trichloroethylene, a carcinogen, into groundwater serving 4 townships in southern Indiana from 2011 through 2019. 40,000 people drank the water. The internal memos surfaced during discovery. Hargrove's compliance team flagged the discharge levels in 2013. Legal reviewed the flag. The decision: continue operations, manage regulatory exposure, suppress the findings from EPA review filings. Weston Falk, CEO, signed 3 memos personally. This is the kind of case you entered the law believing the law was built for. Evidence unambiguous. Wrongdoing in the wrongdoer's own words. You notice, sitting with the file at 7 a.m. in an empty courtroom, how unfamiliar that clarity feels. 2 years of motions, procedural delays, obstruction. You rule against everyone. Verdict, $2.1 billion. Hargrove stock drops 34% the day the opinion publishes. Falk resigns 4 days later. You read about it in a morning summary. You set it down and go back to the next file. You think about Mercer. She would have appreciated this one. A clerk you personally advocated for makes a serious error, a misstatement of controlling precedent that reaches a panel ruling before it is caught. You sit her down. You tell her what Mercer once told you. The system caught it. That is what systems are for. Learn from it and move forward. You hear Mercer's cadence in the sentence. You don't mention this. Mercer dies on a Wednesday in October. Cardiac event. 71 years old. The funeral is on a Thursday. You speak. You say the right things about what it meant to work beside someone who still believed the work was worth doing carefully. You mean all of it. Your salary is $246,000. Loans gone. Children in middle school. They know you are a judge the way they know other facts about the world, accurately, and from a distance. Rank 9, the retired judge. It starts with a tremor. Small, intermittent, in your right hand. Your clerk notices it before you do. She waits 2 weeks before saying anything. When she does, she chooses her words carefully, the way you once chose words with a court reporter who didn't know who else to tell. You know immediately what it means. You set your own retirement date that afternoon. You don't wait for anyone to suggest it. Your last case is a contract dispute between 2 corporate entities. No individual plaintiffs. No one in the gallery. The legal question is narrow. You draft the opinion in 90 minutes. You sign it. You close the file. The ceremony is in the ceremonial courtroom on the 4th floor. A plaque, a framed photograph of your first clerk team, a speech from the presiding judge who gets several details slightly wrong. You smile through all of it. You do not feel what you thought you would feel. You surrender your judicial commission, your PACER credentials, your building access card. Without these, you are not a judge. You are someone who used to be one. The accounting, 31 years, thousands of opinions, 3 cases that visit you at 3 a.m. Rourke walking out of a courthouse on a Tuesday while his victim's mother stood in the hallway. A family whose wrongful death claim was time-barred because their attorney missed a deadline. The near-miss injunction wrong standard, your clerk saying your name once, quietly. A therapist called it PTSD, past events returning as present experience.
You thought that happened to soldiers?
You were not entirely wrong. The DOJ closed the main referral without prosecution. Insufficient evidence. A form letter. You read it once. You think about Mercer often, about the 6-minute phone call, about the fact that Hargrove, the one clean case, the one time the law and the right answer were the same thing, arrived after she was gone. Somewhere in this building, a first-year law clerk is at her desk before 7 a.m. She arrived early because someone told her that is what serious people do. She is reading a file about people she will never meet. The facts are clear. The standard is identified. She writes the answer and feels certain she understands what the law is for. She has no idea what that certainty costs. Not the rulings that follow you home. Not the colleagues you report and the ones you lose. Not the cases where you do everything correctly and the wrong person walks out of the building anyway. The real question was never whether she wants this life. It is what this life will take from her before it lets her keep the title.